agriculture, rural development. The purpose of this press briefing is to explain the Land Court Bill, which has recently been passed by or been approved by Cabinet and is in the process of being transmitted to Parliament. I'll now hand over to Minister Lamola to give us an overview.
Thank you, Crispin. Ladies and gentlemen of the press, Minister of Land Reform and Rural Development, Thoko Didiza. When one reads the words of the founding member and first secretary of the South African Native Congress, Solomon Thabisi Kaplanche, and I quote, "Awakening on Friday morning, June 20, 1913, the South African native found himself not actually a slave, but a pariah in the land of his birth," close quote. Perhaps due to the passage of time, 108 years to be precise, we do not fully comprehend that with a stroke of a colonial pen, literally overnight, our forebears were stripped not only of their dignity, but of their greatest economic asset, which is the land. State-sponsored dispossession orchestrated the triple challenges of poverty, unemployment, and deep inequality, which are the core of Black South Africans' lived experience. The introduction of the Native Land Act of 1913 was not just an act of colonialism, but also an act of systematic economic reconstruction and exclusion. Without the Native Land Act, the migrant labor system would not have been as efficient in the hands of the colonizers. Black South Africans to this day are confronted with the effects of the migrant labor system, which was anchored on land disposition. Therefore, addressing the land question is not only a socio-economic imperative, but it's a matter of restoring the nation's souls. Land justice will restore the soul of the nation. As a commitment to inclusive nation building and constitutionalism, unlike the colonial state, the African National Congress still continues to use laws to address and redress the past imbalances. And the law we are going to introduce today is one of those instruments we want to use to enable society to address the land question. It is against this background that we'll be introducing the Land Court Bill to Parliament. The Land Court Bill is the outcome of the work done by the Interministerial Committee on Land Reform, which is chaired by the Deputy President, Didi Mabuza. The IMC has been seized with implementing the recommendations of the Presidential Advisory Panel on Land Reform and Agriculture. The panel proposed the following with regards to the Land Claims Court. The Land Claims Court be converted into a new land court to adjudicate on all land-related matters and not only restitution. This land court must be given additional responsibilities, both judiciary and extra functions, such as conflict resolution and mediation. The court must have a functional approach which is modeled on the negotiations before litigation, on matters such as expropriation without compensations, which is proposed to Parliament in the expropriation bill. The panel recommend that the land court include the appointment of a permanent judge, president, and 4 permanent judges. The land court should also be required to check that settlement agreements give just and equitable compensation to landowners in line with Section 25 and the new Expropriation Act if the bill will end up being, when the bill is finally passed as law. The IMC on land reform has accepted all of these recommendations and has effected them in the Land Court Bill. So what I've just said above is encapsulated in the Land Court Bill that we are going to introduce to Parliament. In addition to the above, the Land Court Bill also introduces the following. It will also have the Land Appeal Court with a jurisdiction equal to the Supreme Court of Appeal as in relation to matters under its jurisdiction and as a court of record, meaning that any appeal from the Land Court will have to be adjudicated by the Land Appeal Court. This is aimed to further develop land jurisprudence in the country. To help the processes of the court, we are currently in the process to transfer the functions of the Land Rights Management Facility in the Department of Agriculture and Land Reform and Rural Development to Legal Aid South Africa. The transfer of the Land Rights Management Facility will ensure that Legal Aid South Africa has both the finances and capacity required to broaden its reach to the indigent, especially those who seek land justice. The process of transfer has begun, as it does not have to wait for the finalization of the bill. We will announce the processes and the procedures as soon as the whole process is finalized. The efficiency of the procedures and arrangement proposed in the bill will assist to develop our land jurisprudence with regards to the land court and with regards to the land question. For instance, the bill still allows for hearsay evidence for most families who have to rely on oral history and the existence of elders with knowledge of the description, location, and extent of land which their descendants previously occupied. It also allows for expert evidence regarding the historical and anthropological facts relevant to any particular land claim. This bill gives effect to the resolutions of the African National Congress 54th National Congress, namely, to ensure our approach to land reform is based on three elements: increased security of tenure, land restitution, and land redistribution. This bill is a concrete intervention to improve the functioning of all three elements of land reform. It creates a policy frame to ensure that land reform is guided by sound legal and economic principles and contribute to the country's investment objectives and job creation initiatives. While the bill on its own may not be a silver bullet which can help us undo the effects of colonialism, it is an important step which can enable land reform, which is inextricably linked to rural development and addressing the socio-economic challenges that plague us as a nation. Thank you.
Thank you. I'd like to invite Minister Didiza as well to just give us an overview from her perspective.
Thank you very much, Crispin, for inviting me. Minister of Justice and Correctional Services, my colleague, Minister Ronald Lamola, senior members of the Department of Justice and Correctional Services, as well as Agriculture and Land and Rural Development. Welcome, DG of Justice, and I'm happy that you are with us here because you will have to take the mantle in ensuring that the things that Minister, as well as the IMC, has said on this matter, you will champion. Ladies and gentlemen of the media, some years ago, to be precise, 28 years ago, the Interim Constitution Act 2000 was adopted. Approximately 3 years later, in 1997, the final constitution was adopted by the Constitutional Assembly. This constitution, a clear product of many years of struggle, came against the backdrop of a history of apartheid, a central feature of which was inequality based on race. The inequality resulted in the direct assault of the dignity of Black people in particular. It was not only the dignity of Black people that suffered, while areas in general were affluent and Black ones were in the main impoverished and underdeveloped. Professor Sampieter Blanche correctly observes in his book, I quote, A History of Inequality in South Africa from 1652 to 2002, close quote, that the source of race-based inequalities in South Africa can be viewed from three distinct but related historical events: the loss of political power by indigenous Africans to colonial power, the land dispossession as a result of the loss of political power, and the enslavement and exploitation of Black labor. One would appreciate that the effects of these inequalities resulted in the deprivation of land by Black people and continued systematic oppression of degradation. This is manifested by the Land Act of 1913, the Urban Areas Act of 1923, and the subsequent amendments of it and the Natives Trust and Land Act of 1936. These are some of the primary laws directed against the African people, which were directed rather against the African people. The direct effects of these acts were that only 8% of South Africa's total land area was set aside as native reserves, whereas the entire land was enjoyed by a few. At its 54th National Conference, the African National Congress, which is the leading party in government, resolved, among others, to pursue with greater determination the program of land reform and rural development as part of the program of radical socio-economic transformation. Minister Lamola has outlined the approach of land reform by the ANC, and I won't dwell into that. It is, however, against that backdrop that government has taken a policy decision to introduce the Land Court Bill to Parliament in order to deal with land-related disputes in the country in an efficient, cost-effective, and just manner. I must say, Minister, that we are very pleased as the Department of Land Reform that finally we are now going to have a court that can actually adjudicate on a number of issues that our ministry and department has had to deal with over many years. Minister Lamola has already explained the rationale and object of the Land Court Bill, which will, among other things, address the systematic challenges faced by the Land Claims Court and ensure the speedy capacitation of the Land Claims Court by ensuring that permanent judges are appointed. This, in my view, will ease the speedy resolution of land-related disputes in the country and the development of land jurisprudence. I must say, Minister, that since 1998, some of the claims that had been lodged with the Land Claims Court have not been able to be resolved, particularly because of these challenges that I've just highlighted and you too have highlighted. And therefore, we are grateful that we have taken this step going forward to make sure that that court can have permanent judiciary. The financial capacitation and expansion of the mandate of the Legal Aid Board to resolve land-related disputes will ensure a speedy resolution of land-related disputes by using the mediation and arbitration approach. Whilst there is a firm intention of redirecting the expenditure of the Land Rights Management Facility from my department to ensure that the Legal Aid Board resolve land-related matters speedily, we will ensure that working together with the Department of Justice and the Legal Aid Board, we also continue our engagement with Treasury, as we know that matters of land continue to bedevil our society, and therefore we will require enough capacity to be able to deal with this. I have no doubt that the introduction of the Land Court Bill will promote access to land on an equitable basis and contribute to a speedy resolution of land-related matters and contribute to nation building and restoration of the dignity of our people. I thank you.
Thank you, ministers. You can always tell from which era someone comes from by how they refer to things. Legal Aid Board is an old name. It's now Legal Aid South Africa. It's all well. I think, colleagues, you can ask questions to those of us who are watching via live stream. You can ask questions via the GCIS line and the Ministry of Justice WhatsApp group as well. But I'll start with questions from people who are here with us. I see Govan Whittles. Anybody else? No. Govan?
They're not working, eh? Okay. Hi, Ministers, it's Govan Whittles here from ENCA. Some clarity then. Does the government intend to use the land courts to implement expropriation without compensation? Is this the mechanism that you envision that Act, once it's passed, being implemented through? And then for clarity then to the Minister of Justice, what's the date which has been set for people to access the land court? I'm asking here, will the land courts be open for applications from any members of the public? Could the descendants of the Amakwa then approach the land court with the documentation of the grazing licenses and the loan farms given out by Van Riebeck, and then argue that the treaty signed between the VOC and the Amakwa people or the Horinkawa people is not valid? And then will the land court be able to adjudicate on dispossession of groups pre the Union of South Africa and the South African War? Would it then be open to the descendants of Makoma claiming back the Cat River on the basis that the British or Sir Harry Smith didn't honor the treaties that were signed? That's it for now, thanks.
I think we need to have anything on the WhatsApp group.
Thank you, Crispin. There are no questions at this stage.
Ministers, I think you can come up.
No, thank you. If you go to the bill, Gavin, you will see that the bill lists all the legislations for which the court will have jurisdiction in terms of all the bills that are related to the land question. And that will also obviously include the expropriation bill that is currently before Parliament. But we have taken a narrow approach for the courts to gradually start with some of the bills, and that's why we have listed them. But with time goes, as time goes on, the legislations may be increased. But we are starting with the ones that currently the Land Claims Court is handling, with a few exceptions, including the expropriation bill, which is not currently before that Land Claims Court. So that is how the bill is structured. It's aimed to deal with the legislations that we already have, including what the Constitution defined as just and equitable, issues of just and equitable compensation as defined in Section 25 of the Constitution, and whatever may come out of the ad hoc committee in terms of how we define that process of land redistribution or land expropriation. So the land court will be geared to help us in that regard. And the aim is that it must also be able to develop clear jurisprudence and guidelines with regards to compensation and with regards to all the various aspects related to the land question. Hence, we have also put that the Court of Appeal and any other thing that may end up at a court. So we believe this kind of focus specialization will help the country to find certainty, clarity on all the legal and jurisprudential issues that are related to the land question. Thank you.
Any other questions? Minister Didiza feels the questions have been addressed.
We still have no questions on the WhatsApp line. Thank you.
Govan, I see you have a follow-up.
Thank you so much for the clarity. Then I'll take it that that the government does intend implementing the expropriation without compensation through the courts, through the land court. Just wanted to make sure that is clear. I'm asking this question in the context of people who would be affected by expropriation without compensation, and to get clarity on whether or not, when those people are affected, are they then compelled to go to the land court to have that issue resolved? And then if I can just add, now that I have the clarity, these questions. Minister, are you concerned that introducing the land court and the land appeals court and an official court process may tie down land claimants in a court process, which, if it is disputed by the person who currently occupies the land, may find a land claimant in a dragged out process which takes a number of years? And then with the bill, I assume it's going for public participation and comment once it gets tabled in Parliament. What kind of participation are you envisioning from the general public, or what do you want to see the people, how do you want them to contribute to this bill? Thanks.
Yeah, thank you, Gavin. Firstly, in terms of implementation, it is of the expropriation bill. It is within the purview or the province of the Department of Public Works in terms of that implementation, particularly on the part that relates to public purpose. the Department of that deals with the part that deals with the public interest, issues of land claims, issues of land redistribution, and so forth. So what the court is going to do is to deal with disputes, any disputes related to the land question. Hence, I've said all the bills that the courts may end up being seized with are listed in the bill itself. So the court will deal with any dispute that may arise out of the land question, which may also include the dispute that may arise out of the expropriation bill as it is finalized by Parliament, or any dispute that may related to the legislations that have been listed there. One of the criticism of the Land Claims Court was that people were feeling that it's over judicialized, and that people can't really, those that may not have the legal expertise may not fully participate. So this bill allow land activists, like akin to trade unions, representing their clients or their members in the CCMA or in the labor courts or the labor appeals court. So it is almost geared the same way as the Labor Relations Act, if you may want to put it, the CCMA kind of approach, and the labor court and the labor appeals court. Hence, this one also has this inbuilt process of mediation, arbitration, and so forth. And we are hoping that most disputes may end up being resolved at the arbitration and at the mediation stage, because we want a situation where there is involvement, obviously, the land commission, and whoever might be the owner of a property or land or whatever. They could still negotiate before the matter goes to the processes of mediation, and that mediation process may help to resolve the matter before it goes to the land court itself. And we are hoping that most claims could end up at that stage, but sometimes they can be disputed, hence the court is there. But the court is established as a matter where people, when they can't resolve their mediation processes. And that is the reason why we also had some kind of discussions with the Land Commission, because one of the criticism on the Land Commission was that when it mediates and also settle the dispute, sometimes it becomes a referee and a player. So these courts give them that kind of leeway so that they can negotiate without being a referee and a player. There's an independent process that will allow the process of mediation which is inbuilt through the courts. And we believe this mechanism will help soften some of the teething challenges that the Land Commission is currently dealing with, and will also help them to also find amicable solutions with some of the landowners that they will be negotiating with and engaging on, including helping the land claimants or those that will be part of the process. So in that regard, the matters that will end up at the land court will almost be the same way as the labor court. You can see that it does not handle all matters of labor. Most of them are handled and they end at the CCMA or at an arbitration level. So we are hoping that also with this introduction, most of the land disputes will end up at that mediation and also at an arbitration level. And that is where we're going to put most of our efforts so that the issues are resolved. Thank you.
Sorry, Minister, I see you coming up now. Let me add another question for you then,
Okay.
which has just come from the ministers. So the land activists now having access to legal aid, essentially, to take matters to the land court is something which would be a positive step for them. And I wanted to know, what's your message to the land activists in South Africa right now with the announcement of this bill?
Well, thank you very much. My message to the land activists, fortunately, we do have a forum of engagement with the land activists already in South Africa to ensure that we actually allow their input on policy formulation. They are able to bring up issues that we may not be aware of, particularly as it relates to labor tenants, issues of farm workers, which actually has a dynamic relationship with ourselves. Sometimes the representation, even currently, that we make on behalf of the farm workers when they are evicted are brought to us by your land activists in the main. So what I would actually say is, it's my message to the land activists is for them to be able to participate in the public hearings, to give their comments to the development of this bill as it goes to Parliament, so that they can also share their lived experience having worked with these communities and individuals who are affected. I just wanted to say, one of the things about the land court, instead of actually stifling the land claims process, it's actually going to help to accelerate. You'd recall that at some stage in the mid-2000s, we had to amend the Restitution Act of 1995 to allow for mediation where there are no disputes through amendment of Section 42D, which actually allows for an administrative process that if there is no dispute on a claim by the person who is a landowner, not disputing that indeed people were moved here and is willing to settle, that actually follows an administrative process. It doesn't even enter to court, in court rather. Instances where such matters are in court, this is where, in my view, the land court bill will assist. Once it's an act, it would allow for mediation where such matters are not really difficult, that they might have to wait for, a judge, for instance, but can be settled through mediation. It therefore would actually enable us to fast track the processes that we have currently. And having been part of the engagement with the Minister of Justice and the Land Claims Commission Office, having engaged, we are fully aware and appreciative of what we are actually trying to do in unlocking the land restitution in particular.
Thank you, ministers. If there are no questions on our WhatsApp line, I think then we can draw the press conference to a close. Thank you very much for your kind attention. No, I was saying,